Next month marks 30 years since the election at which 3 Supreme Court justices lost their retention elections. The first time any justice had lost such an election since retention elections were started in 1934. Soon after the election, it was newly confirmed Chief Justice Lucas who analogized the election to a 100-year flood and said, "It was a very unusual circumstance, which I do not anticipate happening again." So far, it hasn't, at least not in California. We're privileged to have a distinguished panel to discuss the 1986 election, judicial elections in general, and those elections' effect on how courts operate. To adequately describe the credentials and accomplishments of our panelists would leave little time for the program itself, so I'll be brief and inadequate. Erwin Chemerinsky, to my immediate right, is the founding dean and distinguished professor of law and Raymond Pike Professor of First Amendment Law at UC Irvine School of Law, with a joint appointment in political science. The latest of his 8 books is The Case Against the Supreme Court. And that's the U.S. Supreme Court he's talking about, not the California Supreme Court. Joseph Grodin is a distinguished emeritus professor at UC Hastings. He is also an author of numerous books, including In Pursuit of Justice. In that book, you can read about how his teenage daughter accepted on his behalf his appointment to the Court of Appeal. Cruz Reynoso is the Bootchever and Byrd Professor of Law Emeritus at UC Davis School of Law. He served as the Vice Chair of the United States Commission on Civil Rights and has received many awards, including the Presidential Medal of Freedom, the nation's highest civilian honor. But of all of Joseph Grodin's and Cruz Reynoso's credentials, the most relevant to this program are that they both served on the California Supreme Court and were 2 of the 3 justices who lost their seats in the 1986 election. This gives them a special perspective on today's topic. So without further ado, please join me in welcoming our panel. And to start the program, I'm going to turn it over to Justice Grodin for a history of judicial election systems in California and nationally.
Thank you, and congratulations to everybody for getting up so early on a Sunday morning. I don't know what it says about all of us that we don't have anything better to do at 8:30 on Sunday morning, but here we are. One way to look at the history of judicial election law in California is through the prism of our notions of what it is, what we expect from judges, what judges are supposed to be. And we have a very schizophrenic, ambivalent view about that. On one hand, we think of judges as referees calling balls and strikes, as Chief Justice Roberts famously said in his confirmation hearing. On the other hand, we may think of judges as super legislators, making the law to suit their own value systems, legislators in robes. Or we may think of judges as somewhere in between those 2 extremes, and if so, exactly how to describe their function and what the implications of that description are quite controversial. At the beginning of our nation's history, there was no question about the choice of the framers of the U.S. Constitution. Judges were to serve for life, and that reflected a view that there was something quite different about judges. And the early decisions of the U.S. Supreme Court were all unanimous decisions, reflecting the notion that there was some consensus on what the law is, and the law was something out there to be found and not to be made. Somewhere around the middle of the 19th century, the Jacksonian Revolution, revolution of populism, brought into view another view of judges, and that was the judges are part of the political system. They're deciding cases which involve, in many cases, bringing to bear value judgments. And since that is so, we might as well, that is, we the people, might as well have a say in how judges are selected. And so there was a wave of populism which led to the treatment of judges' selection pretty much in the same way that legislators were selected at the state level. And that was true in California in 1849 when our first Constitution was adopted. We had judges elected, and they were nominated by political parties. One of the most controversial of the first judges was David Theyre. He was the nominee of the Know Nothing Party. Judges were periodically elected, and I remember my chambers at the Supreme Court, yours too, Cruz, I'm sure, had a plaque with all of the former judges who served in those chambers, and the dates on that plaque were remarkably short, reflecting the fact that they were ousted from office by elections. Then, toward the end of the 19th century, there developed a different political perspective, that of the progressives, which downplayed the significance of political parties and led to the characterization of judges as nonpartisan officers along with many local officers. So you did not run on political labels, you ran on your own name. But still you ran, and you were subject to losing elections. There was considerable discontent in some quarters with that state of affairs. The Commonwealth Club of San Francisco took the lead in trying to develop alternatives, and what they came up with by way of compromise was what we have today. In 1934, the California Constitution was amended to retain elections, for trial court judges, but in the case of appellate judges, that is Court of Appeal and Supreme Court, there was a 12-year term, but you had to appear on the ballot at the first gubernatorial election following your appointment in a retention election, and people voted yes or no. And that was widely viewed as a way of protecting judges against political influence, because it was assumed that unless a judge did something terribly wrong, the retention election would be pretty much of a rubber stamp. And that assumption carried the day until 1986, when things changed. And let me turn it back to you, David. That's how we got to where we are. Well, I should say, by way of addition, that from time to time there have been proposals to change the system. The likelihood of changing it to eliminate any elections for judges and to substitute life tenure as a political matter seems probably impossible. But I have suggested, and others have suggested, that we might well consider a model that is exemplified by the New York Court of Appeal. After an election in New York that was particularly contentious and ugly, the reaction was such that the people supported an amendment to the state constitution providing that judges of the New York Court of Appeal, which is of course their highest court, would serve for 14 years, appointed by the governor to serve for 14 years, and then no election, subject to reappointment by the governor, but the governor was free to select someone else as well. That was combined in New York with a merit system for appointment, which we can talk about if we get to it. But at any rate, that presents itself as an alternative to what we have. Now I turn it back to you, David.
Well, also the 1986 election was presaged to some degree by when the Supreme Court decided in the 60s, struck down the restrictive covenant initiative. Isn't that?
Yeah, they struck down the law which said that everybody has the right to sell or rent their house to anybody they liked. And Chief Justice Traynor wrote that opinion, and the lore around the court was that Traynor had his bags packed, ready to leave. He was up for election in the following year, and there were billboards around the state, sponsored by the John Birch Society, asking people to vote against Chief Justice Traynor. As it turned out, he had nothing to worry about, but that certainly that threat was hanging over the court as it hangs over the court today.
Thank you, Justice Grodin. I'd like to ask Dean Chemerinsky to discuss some of the Supreme Court cases that limit or don't limit money in judicial elections and speech in judicial elections.
Thank you. It's such a tremendous honor to be on this panel. Joe Grodin and Cruz Reynoso are two of my heroes. Being with them, I sort of feel like the Sesame Street answer, which of these doesn't belong? Also, David Ettinger is truly one of the very best appellate lawyers in California and the country. When our appellate litigation clinic needed an additional lawyer supervisor, David was the very first person I called, and I'm thrilled now that he's an adjunct professor at UCI Law School. There have been 4 Supreme Court cases directly relevant to what we're talking about this morning. 2 dealt with due process and judicial impartiality. 2 dealt with judges' speech in the context of election campaigns. So when we talk about what might be possible with regard to future regulation, these are the data points to begin with. The first of these cases was Caperton versus Massey Cole. Caperton versus Massey Cole was decided in 2009. A jury in trial court in West Virginia issued a very large damage judgment against Massey Cole, one of the largest coal companies in the United States. This time, the officials from Massey Cole spent $3 million in expenditures to get their chosen candidate elected to the West Virginia Supreme Court, a man by the name of Brent Benjamin. The $3 million was a very large percentage of all of the money that was spent in this election campaign. Benjamin defeated the incumbent by several hundred votes. At this point, Massey Cole's appeal from the damage judgment against it comes to the West Virginia Supreme Court. Caperton, the successful plaintiff, moves to have Benjamin disqualified from participating. Benjamin refuses to recuse himself. The West Virginia Supreme Court, in a 3-2 decision, reverses the judgment against Massey Cole, with Brent Benjamin being in the majority. The issue before the United States Supreme Court was whether due process was violated by Brent Benjamin participating. The Supreme Court, in a 5-4 decision, found that due process was violated. Justice Kennedy wrote the opinion for the court. Justice Kennedy's opinion focused on how the very core of due process is the requirement for an impartial decision maker. Here, there is an objective risk of actual bias. At the end of the opinion, Justice Kennedy says, I think instances like this will be rare. Chief Justice Roberts wrote the dissent, joined by 3 other justices, and said, I don't think this is going to be rare. And in fact, his dissent focused on dozens of unanswered questions. If the facts of this case sound familiar, maybe it's because you read the John Grisham novel, The Appeal, which has exactly the same story there in fiction. And as I was saying to David this morning, I'm now involved as co-counsel in a case pending in federal court in Illinois with very similar facts. So it belies the notion that this is something that's rare. The case that I'm involved in now is a case called Hale versus State Farm Insurance. A trial court in Illinois awarded a $1 billion judgment against State Farm for directing that car repairs be done with substandard parts. The Illinois Court of Appeal, in a very strongly worded decision, affirmed the liability and the $1 billion judgment against State Farm. The allegations of the suit that I'm involved in are that State Farm then, through many subterfuges and many fronts, spent a great deal of money to get their chosen candidate elected to the Illinois Supreme Court, a man by the name of Lloyd Carmeier. Carmeier got elected. There was a motion to have him recused, and the argument was, State Farm didn't really spend very much to get him elected. He didn't need to be recused. He participated, and his participation is the deciding crucial to the Illinois Supreme Court reversing the judgment against State Farm. Many years later, the plaintiffs from this higher investigator, and they believe that they've discovered many ways in which State Farm spent an enormous amount of money to get Carmeier elected and then lied about it. So a class action suit got filed in federal district court in Illinois under Rico, claiming that State Farm engaged in fraud. Rico, as you may know, has treble damages. So this is now a lawsuit for $3 billion against State Farm. State Farm moved to dismiss on issues of federal jurisdiction, which I got involved in the case. The district court denied the motion to dismiss. The Seventh Circuit affirmed. Just 3 weeks ago, the district court certified the class against State Farm, so the suit is going forward. But again, it's facts remarkably like Caperton versus Massey Cole, remarkably like John Grisham's novel, The Appeal. I said there were 2 Supreme Court cases dealing with due process and impartiality. One is Caperton versus Massey Cole. The other came down in June of this year. It's Williams versus Pennsylvania. And while it doesn't involve campaign spending, it is relevant, I think, with regard to the underlying issue of the constitutional requirement for impartiality. Terrence Williams was prosecuted for capital murder in state court in Pennsylvania. At the time of his prosecution, the deputy district attorney went to then district attorney Ronald Grodin and asked him for permission to seek the death penalty. The district attorney, in a handwritten note, approved seeking the death penalty. Williams was convicted and sentenced to death. The Pennsylvania appellate courts affirmed the conviction and the sentence. Many years later, another lawyer for Williams brought a collateral proceeding in state court, a state habeas proceeding, and the claim was that the DA's office had violated Brady versus Maryland and had not turned over material exculpatory evidence as required by the Constitution and the rules of ethics. The Pennsylvania trial court ruled in favor of Williams, overturned his conviction and sentence. The state of Pennsylvania then appeals to the Pennsylvania Supreme Court. Who then is the Chief Justice of the Pennsylvania Supreme Court? Ronald Grodin, the very same person who had been the DA who had approved the death sentence, the very same person who was the DA at the time of the prosecution. Williams' lawyers moved to disqualify the Chief Justice, or say at the very least he should refer the disqualification motion to the justice on the court. He denies both motions. The Pennsylvania Supreme Court, 6-0, overturns the trial court, reinstates the conviction and the sentence. The issue before the Supreme Court is, was the participation of this man a violation of due process? And the Supreme Court, in a 5-3 decision, concludes that due process is violated. Here, too, Justice Kennedy writes the opinion for the court. Once more, Chief Justice Roberts dissents, joined here by Justice Alito. Justice Thomas writes a separate dissent. Once more, the Supreme Court says that the very core of due process requires an impartial decision-maker. Court says this is an objective test. Is there an unreasonable risk of actual bias? And the court finds here that there was. And the court says it doesn't matter that the Pennsylvania Supreme Court was unanimous. This is structural error. Harmless error analysis doesn't apply. Now I want to talk about two cases with regard to judges' speech in the context of election campaigns. And again, they're relatively recent cases. The first is Republican Party of Minnesota versus White from 1992. Minnesota had a provision in its Code of Judicial Ethics that candidates for elected judicial office could not make statements about disputed legal or political issues. The Supreme Court, in a 5-4 decision, declared that unconstitutional. And the ideological composition of the majority and the dissent are interesting here. Justice Scalia writes the opinion for the court, and it's joined by Chief Justice Rehnquist, Justice O'Connor, Justice Kennedy, and Justice Thomas. Justice Ginsburg writes the lead dissent. Also in dissent are Justices Stevens, Souter, and Breyer in 2002. And the interesting thing here is you find that it's the conservative justices who are more on the free speech side, and it's the liberal justices who would have upheld the regulation of speech. Justice Scalia and Justice O'Connor, in a majority and a concurring opinion, both say, if a state chooses to have judicial elections, it's turning the candidates into politicians. They should have the same free speech rights as anybody else who's running for elected office. Justice Scalia's majority opinion has a great deal of discussion with regard to how do we decide what impartiality means. Is the fact that somebody has made statements in a campaign enough to undermine impartiality? Republican Party of Minnesota versus White is 2002. 13 years later, in Williams-Yulee versus Florida State Bar, the Supreme Court seems to take a different approach. Leona Williams-Yulee ran for election to be a trial judge in Florida. At the time she announced her campaign, she sent letters to prospective supporters encouraging them to contribute money to her campaign. Alas, she lost her election bid. She was not chosen to be on the state bench. And then, to add insult to this injury, the Florida bar brought disciplinary proceedings against her. Florida is one of 31 states that has a rule that candidates for elected judicial office cannot personally solicit or receive funds. Williams-Yulee raised the First Amendment as a defense to the bar discipline. The Florida Supreme Court ruled against her, and in the spring of 2015, the United States Supreme Court ruled against her, here in a 5-4 decision. Again, the ideological composition of the court is noteworthy. Chief Justice Roberts writes the opinion for the court, and here it's joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Justice Scalia writes a vehement dissent, and it's joined by Justices Kennedy, Thomas, and Alito. Chief Justice Roberts stresses the importance of public perception of impartial judges. Here, Chief Justice Roberts says, admittedly, this is a content-based restriction on speech. Content-based restrictions on speech must meet strict scrutiny that be necessary to achieve a compelling interest. He says the interest in preserving the appearance of impartiality of the judiciary, the importance of preserving public confidence in the judiciary rises to the level of a compelling interest, and he says that this law is neither so overbroad or under-inclusive as to fail the requirement for narrow tailoring. Justice Ginsburg writes an opinion that's occurring in the judgment, and she says that the Supreme Court should go even further in allowing restrictions with regard to judicial campaigns. Justice Scalia writes a dissent and says, what happened to Republican Party in Minnesota versus White? We said there, any time a state chooses to have judicial elections, it's turning the candidates into politicians. They should have the same free speech rights as anybody else. I think there is a real tension between Republican Party Minnesota versus White and William Julie versus Florida State Bar, even though they're only 13 years apart in terms of when they were decided. Because I think that the central premise of Republican Party Minnesota versus White is when a state chooses to have judicial elections, it's turning those who are running into politicians. By contrast, in the very first paragraph of his opinion, William Julie, Chief Justice Roberts declares, judges are not politicians even when they are running for elective office. So I think that the bottom line from these cases is that the current court is going to be much more willing to allow government regulation, especially in the area of campaign finance, more generally in the area of speech, for those who are running for judicial office. I think it's quite possible that the Supreme Court might be willing to allow restrictions for campaign finance for judicial elections that it doesn't allow with regard to other elections. For example, since Buckley versus Vallejo, the Supreme Court has said that expenditure limits are unconstitutional elections. Might expenditure limits in judicial elections be allowed because judicial elections are different? Citizens United says that corporations have the right to make unlimited expenditures. But might there be limits with regard to corporations based on the reasoning of William Julie and the reasoning of these other cases? The key difference, of course, from Republican Party Minnesota versus White and William Julie versus Florida State Bar is Chief Justice Roberts. That whereas Chief Justice Rehnquist had been with the conservative justices in the majority, Chief Justice Roberts joins the liberal justice here, and I think it really opens up the possibility for much more regulation with regard to judicial elections being upheld than with regard to other kinds of elections.
Thank you, Erwin. But in the absence of those regulations right now, recently there have been great increases in the amount of money that's being spent in judicial elections. I don't know whether any of you want to comment on that, on how much money is being spent right now in judicial elections.
Well, in fact, we have seen, not in California, but in other states, vigorous campaigns against incumbent judges on the Supreme Court of those states, some of which campaigns have succeeded, others have not. But we have seen, particularly with Citizens United and so on, that folk can raise any amount of money that they want to run against incumbent judges, and it seems to me that that might encourage folk, even in California in the future, if some interested economic group, a corporation, an insurance company, is unhappy with the rulings of the California Supreme Court. It seems to me that they probably have the resources to then launch a campaign against a justice or against all of the justices for that matter. So I think that we are actually in an era now of even greater danger to incumbent judges than we were even in '86.
There's some materials that David did a great job putting together, and I'll just read one quote. It's from Alicia Bannon from the Brennan Center, and it's a study from this year in 2016. It very much supports what was just said. Average spending per seat in retention elections nationwide has increased tenfold from 2001 to 2008 to now 2009, 2014. It's gone from an average of $17,000 per seat to $178,000 per seat, respectively. Not long ago, a judge on the Superior Court in Los Angeles said to me that the estimate was that it was going to take about $1 million to be able to run to be a Superior Court judge. The judge said that the judges would talk in the judges' lunchroom about which law firms contribute, and then the judges would have to go out on the bench and hear from those very law firms. It's why 7 out of 10 people in the country in opinion polls have said that they believe that money in judicial elections undermines the fairness of the judicial process. So the escalating amounts of money that David's talking about have this effect. And maybe as a transition, as we go back 30 years, I mean, one of the things that's interesting is whereas the focus of the election campaign against Chief Justice Byrd and Justice Grodin and Reynoso was very much on the death penalty, the money for the campaign very much came from the insurance industry that was upset about the pro-plaintiff rulings of the California Supreme Court. And that was 30 years ago. And think about how much the expenditures have increased dramatically since.
I'd like to share with you my own experience in that regard. Excuse me. First of all, I should tell you that there are many elements that come into an election. When I was, and the same rules apply to the Court of Appeal as to the Supreme Court. When I was appointed to the Court of Appeal, then I had to go before the voters. There were only 3 of us at that time. The Court of Appeal in the 3rd District had 7 judges, and 3 of us were before the voters at that time. A local newspaper ran a headline that said, "The candidates nobody knows," and they had a picture of the 3 of us and said something about our background. But I think that's actually a reality. Most citizens don't really know the background or how judges have really ruled. If there's a campaign against them, no doubt there will be a mischaracterization of how the judges have ruled. So the election went forward, and the 3 of us, let me tell you how it came out. There was a judge by the name of Hugh Evans who, to put it lightly, was not the most distinguished judge on the Court of Appeal. He came in number 1 in terms of the votes. The other judge who was on was the presiding judge by the name of Robert Puglia, spelled Puglia, an Italian name. So he came in number 2. And then Cruz Reynoso, with a Spanish name, came in number 3. So you can see that even the names influence the voters, whether or not they're distinguished or not. Puglia was a very distinguished judge, and he came in number 2 to a judge who was not very distinguished, for example. Now, I should tell you that when I was in the military, at basic training, apparently the folk in the military hadn't heard of too many people whose first name was Cruz. So they got mixed up, and they would call me Bruce. And then at that time, they put the first letters of your last name on everything that you had. So it was R-E-Y. So they assumed my last name was Reynoso. So when I was in basic training, I learned to respond to Bruce Reynolds rather than Cruz Reynoso. And my friend said after the election for the Court of Appeal, "Cruz, if you had run as Bruce Reynolds, you would have come in number 1." So you see that even what seems to be completely unimportant in terms of the judicial capacity of a judge, other things get involved. Then, with respect to the Supreme Court, the '86 election of the Supreme Court, I was very reluctant to even appoint a committee to defend me because it seemed to me that would be getting involved in politics, and judges should not be involved in politics. And then it seemed to me that those who had to defend the Supreme Court actually were the lawyers, particularly the bar. But since that was the first frontal attack on the Supreme Court, I think the bar was not quite sure how to proceed in defending the judges. So basically, I'm not sure that any organized group actually educated the public about the role of the Supreme Court and the role of the judges and so on. So what the public heard were simply attacks on the judges that had been identified as the bad judges. I note, and hopefully that it influenced them, that one of the judges was the first female ever appointed to the Supreme Court. Another judge was Jewish, and another judge was Latino. I hope that didn't influence them, but I think it may have, because that may have been part of the political evaluation in terms of which judges were more vulnerable to a political attack. So as I say, and then I worried, frankly, that under the law, those who had contributed to the campaign would be published. So we actually would know which lawyer or which firm contributed against us. And my worry was, what happens when the lawyers come and argue before us, and I know that one lawyer contributed to my campaign, another lawyer contributed against me. I would hope that would influence my ruling, but frankly it worried me, and it certainly made it more difficult to be as impartial as a judge should be. Near the end of the campaign, I was convinced that I had to appoint a committee. And I did, and actually we raised quite a bit of money. I think like $1 million in a few months. But of course in California, if you have a statewide campaign, $1 million means practically nothing. You know, by the time you would go on television, which we did not, etc., the money would be gone. But I did appoint a committee, and they hired a consultant. The consultant really couldn't do very much because we didn't have that much money, but he did one good thing that helped me, and that is he apparently signed up with another group that did day-to-day evaluations in terms of how the voters were feeling, and by doing that, he was able to tell me a couple of days before the election that I was going to lose. And so I prepared for that. And so my friends would call, and they would want to have victory parties and all that, and I would say, oh, thank you very much, I really appreciate it, but I'm just going to watch the returns on the television, which I did, and of course we were not returned to the court. I hated to return all the phone calls from the press that I was sure were coming in the next day. So my wife and I took the day off. Even though it was November, it was a beautiful sunny day. We have a little ranch near the foothills of the Sierras. My wife used to say the foothills of the foothills. So we went up to the little town of Jackson, had lunch, went to a museum that only opens 2 times a week, and it was one of the loveliest days that I've ever spent. The next day I started returning all the phone calls to the press, and they'd say, "Gee, we hear you were so downhearted that you went incognito for a day." I hated to tell them that it was one of the nicest days that I had had. I answered the questions. I never took it personally. I took it as a political campaign. I felt that it had nothing to do with the merit of my being a judge on the Supreme Court. So as I say, I didn't take it at all personally. So afterwards, I had a lot of offers from different law schools, different law firms. I accepted one of those offers and went on with my life. And I must say that if I had continued to be on the Supreme Court, I wouldn't have been able to have been appointed to the U.S. Commission on Civil Rights and many other things that I did. So life goes on.
Cruz, I remember. I remember your saying something during the course of the campaign to the effect that if you believed half of the things they were saying about you, you would have voted against yourself.
Absolutely. I mean, we were being attacked for all kinds of things. We didn't have the resources to respond to it. So indeed, I would say, if I believed half the things they're saying about me, I'd vote against me. I mean, they would say these lawyers are not following the law. Well, these judges are not following the law. Well, judges are supposed to follow the law. And there was not enough of a response by the press, by the Bar Association and so on to convince the voters that wasn't true, that in fact we were following the law. So if I believed even half of what they were saying about me, I would have voted against me.
Let me just, if I may, put a little more flesh on this idea of what it is like to run for office as a judge in a contested election. Cruz has talked about the idea of raising money, and like him, I was told by my advisors that I had to have a campaign. If I was going to have a campaign, I had to raise money. And if I was going to raise money, the only way to do that was by asking people personally to contribute money. Doing that through surrogates would not be effective. And in retrospect, I should have said, the hell with that, but I did it. And it was one of the most degrading experiences I can recall, to call up somebody on the phone and say, hey, I'm having this campaign, and would you contribute to it? People did that, and they did it in good spirits, but it is a terribly poisonous atmosphere to have judges calling lawyers who are likely to appear before the court and ask them for money. And like Cruz, I worried about what would happen if I won. And I'd be sitting on the bench and confronted with a lawyer who, because I was required to sign off on reports of contributions, I was presumed to know whether they did or did not contribute to my campaign. There is also the problem of how you go about conducting a campaign. That is, what is it that you say to people as you go around the state to persuade them to vote for you? And you can talk about judicial independence, and we as lawyers have a pretty good idea of what that means. But for most of our fellow citizens, frankly, that doesn't mean a whole lot. The idea of judges being independent is a rather negative concept, which implies that they're beyond accountability. And the alternative was to campaign substantively on the basis of opinions. Now, what on earth was I supposed to say about that? As Professor Chemerinsky said, most of the money against us came from insurance companies and growers and others who were unhappy with our decisions. So was I supposed to stand in front of an audience and say, you should vote for me because I voted to expand tort principles in this context and hold insurance companies liable for product liability? The idea that should be a ground for campaigning positively or negatively against a judge seemed to me to be wholly contrary to our notion of what judges should be. And the so how we deal with that, how we get around that, those problems, I don't know. I mean, I'm in favor of putting financial limitations on judicial campaigns, and I agree with Dean Chemerinsky that recent decisions of the court suggest that it may be prepared to uphold those kinds of restrictions, even though they would not be valid in the context of a purely political election. But I think we have to give serious thought to these questions.
And I happen to disagree with Malcolm Lucas, with whom I served on the court, that he thinks this type of election will never happen again in California. It seems to me that with the changes of how to raise money, and with the example of what's happened in other states, that any powerful, economically powerful group or industry in California, if they become unhappy with the Supreme Court, would be able to launch a campaign with the same dangers, from my point of view, as happened last time. And I may be prejudiced, but my recollection is that the California Supreme Court, at the time that I was on the court, had the reputation nationwide of being the premier state Supreme Court in the country. And sad to say, after the election, that reputation quickly evaporated. And my own view is that the court has slowly been gaining a better reputation in the country, not quite to what it was before. I mean, you have to take a look at judges like Tobriner and Mosk and so on to understand how easy it was to have the court be considered the premier Supreme Court of the country. But we lost in California that reputation because, quite logically, those who did not like the incumbents didn't like the fact that it sought to protect very often, if it could be done constitutionally, the weak and the disadvantaged. And the new court, quite logically, because of who had appointed them. And so far as I know, it may be the first time that at that time certainly it was the first time that it happened quickly, that the court went from being one court to another, because the governor then appointed 3 judges, and Lucas was there already, so he had appointed 4 judges very quickly. And so the whole tenor of the court changed, being far more prosecution-minded, far more industrial-minded than the court had been before. And I think maybe that's one of the reasons why it lost the reputation that it had of being the best state Supreme Court in the country. And I think, frankly, and again I may be prejudiced, that was too bad for the people of the state of California.
There's something else I think that needs to be said here, and that is that the threat posed, the problem posed by these sorts of elections do not depend upon whether or not there is another campaign to remove judges. I mean, the fact that we've gone 30 years and there's not been any serious campaign to remove judges, there have been threats of it, but nothing that approached the level of the 1986 campaign. That fact should not make us feel easy about the question, because we have to consider the problem that is posed by the possibility known to sitting judges that they could be challenged in a retention election if they offend certain segments of the society sufficiently to invoke a campaign against them. And that kind of problem, which Justice Kaus referred to as the crocodile in the bathtub, when he was asked whether the existence of the campaign had any effect upon his decision-making. And I'm not sure, Cruz, whether either you or I are in a position to say whether the campaign had an effect upon our decision-making, because it's very difficult to know under those circumstances. You tell yourself, I'm going to ignore that. Governor Deukmejian, who first announced his opposition to Rose Bird and withheld judgment on Cruz and myself, pending our further decisions in death penalty cases, sending a message that if you reverse too many death penalty judgments, I and my party will be against you. I told myself, I'm going to ignore that. But how do you do that? How do you ignore the crocodile in the bathtub? You don't want to bend over and say, well, for that reason, I'm going to start affirming, or I'm going to start reversing death penalty judgments. I seriously considered the possibility of recusing myself from deciding death penalty judgments until the election was over, so as not to give the appearance of being affected by the campaign, because I knew that if I voted to affirm a death penalty judgment, our friends among the district attorneys would say, well, he's only doing that in order to curry the favor of Governor Deukmejian and positive votes.
I found it instructive that two senators called a press conference one time, and they had a list of all the cases that the Supreme Court had ruled on that from their point of view were erroneous. But they had included in the list many cases that had been decided before Rose Bird was appointed to the bench. And so the reporter said, why are you criticizing Rose Bird for cases that were decided before she was appointed to the bench? And they said, well, that's perfectly logical. They said, it just shows how bad the Supreme Court has been for many, many years.
I want very much to agree with them, and I want to put in a slightly larger national perspective, because what we saw in California when Justices Reynoso and Grodin and Chief Justice Bird were not retained has happened in other states around the country. And then that sends a message to judges around the country. You can focus on the Iowa Supreme Court. It unanimously declared unconstitutional an Iowa law that prohibited same-sex marriage. At the next election, 3 of those justices who had been in the majority, in a unanimous decision, were voted off the bench. We're going to talk about Penny White, a justice on the Tennessee Supreme Court. She was in the majority in a 4-1 decision to overturn a death sentence. She did not write the majority opinion. She was denied retention on the bench. Or an instance that didn't get nearly as much publicity but shows how insidious judicial elections can be. A woman named Deborah Gosti, who was the Chief Justice of the Nevada Supreme Court. The Nevada Supreme Court, in a 6-1 decision, ordered that the state legislature fund the public schools as required by the Nevada Constitution. She went from the justice on the Nevada Supreme Court with the highest approval rating immediately to the lowest, and her campaign consultants told her she had no chance of retention to the bench. There are statistics that support exactly what Justice Grodin was saying in terms of the quote from Otto Kaus of judicial election being like crocodiles in the bathtub. And again, this is in the materials. A study has been done over the last 15 years of death penalty results in those states that have electorally accountable judges as compared to those states that have appointed judges who don't face electoral accountability. In the 15 states that have the death penalty and judges are electorally accountable, the reversal rate in death penalty cases is 11%. But in the 7 states that have judges who are not electorally accountable, the reversal rate is 26%. Studies have been done over and again that show that states that have judges who have faced electoral review are far less likely to reverse death sentences than judges in states that don't face electoral review, which really shows exactly what the effect is of having a crocodile in the bathtub.
So what are we going to do about it?
Yeah. Well, it seems to me that we do need a change in California. and we can look at other states to see what they do. Justice Grodin suggested one, and that is to maybe appoint judges for a given number of years. I think it's Pennsylvania that has 15 years, where the judge is appointed or served for that term, subject to being reappointed by whoever happens to be the governor when the term is over. But they don't run for elections, and so it seems to me that they would not have the same pressures that we've been talking about. Frankly, from my point of view, though Justice Grodin, I think, has expressed the view that it's probably politically impossible in California. I don't see anything wrong with life appointments for trial court judges, for appellate judges, for Supreme Court judges. That certainly would mean that the judges don't have to worry about some powerful economic group coming after them. It seems to me that when we look at the federal system and we look at the state system, in my view, the federal system has served us well. And so if we were to adopt a federal system, it seems to me that, from my point of view, that actually would be the best approach. Even at the trial court level, in a place that was indicated like Los Angeles, if there's an open seat, and in such a way that at the end of the term, so the governor doesn't I guess 90% of the judges are appointed by the governor in that type of situation, but very often they're not. In fact, I was supporting a certain candidate one time, and he had opponents, but in a place like Los Angeles, it takes a lot of money to even send out one mailer, and the lawyer I was supporting won, but you always wonder what the impact on that candidate will be, that they had to run a political campaign to get onto the bench. So I think that some of the things that we've been talking about affect not only the Supreme Court, but maybe the Court of Appeal, maybe the trial courts.
I agree with those solutions. I think we could come up with other possibilities as well. I'd be comfortable, for example, for a 20-year non-renewable term. I've come to believe that we should have term limits for United States Supreme Court justices. And I've come to think that might be a good thing for federal district court and Court of Appeal judges. And so we can argue about the number of years, whether it's 18, 20, 25 years, but then nobody would ever have to face a re-election, no longer needing to raise money, no longer worry about pleasing the voters. The problem is how to get there. People aren't likely to vote themselves out of power. There was a very high-profile effort in Nevada not that many years ago to eliminate judicial elections in Nevada. Sandra Day O'Connor, after she left the bench, played a large role in campaigning against that. It was defeated by the Nevada voters. And so I think if an initiative were put on the California ballot to eliminate judicial elections, the special interests that want to be able to have that effect would spend an enormous amount of money to defeat the initiative. Yeah. That's what concerns me.
I think special interests, the nature of parties who are interested in affecting judicial elections, I think we have to say, is not necessarily limited to conservative interests. Trial lawyers in some states have expended huge amounts of money to influence state elections. And it's interesting to reflect on the fact that back in 1934, when it was being considered what to do in California about a judge in Santa Clara County who is being accused of imposing an overly lenient sentence on a young man who was found guilty of sexual molestation.
I have written about this. I've signed a letter against the recall. I think everybody remembers. Though it's interesting how many people don't know the exact facts of what happened and how the facts have gotten distorted. Tragic fact. Brock Turner, a Stanford student, was found molesting an unconscious woman. Her blood alcohol level was 3 times the legal limit. She wasn't responsive to police. 2 joggers saw him. He was convicted. It was of sexual contact with an unconscious person, an attempted rape. The prosecutor recommended 6 years in prison. The probation department recommended 6 months to a year in imprisonment. And the judge chose 6 months as the time for imprisonment. And often the probation department recommendation is not told as part of the story of what happened. 6 months in jail followed by 3 years of probation is the sentence. The victim read a very eloquent statement that got national attention, and then a recall effort is developed against Judge Persky. Have we ever heard of an effort to recall a judge for imposing too harsh a sentence? First case I ever argued in the Supreme Court was a man who was sentenced to life in prison with no possibility of parole for 50 years for stealing $153 worth of videotapes from Kmart stores. No one would ever think that we would have a recall effort because the judge's sentence was too harsh. But if somebody is perceived as too lenient a sentence, then there's a recall effort. What really concerns me is I want judges to impose the sentence that they believe is correct under the facts. I could certainly agree here. I think this sentence was too lenient. I would have imposed, if I was a judge, a harsher sentence. But that doesn't mean you recall the judge from the bench. Recalling the judge from the bench, threatening the judge with recall from the bench, sends such a clear message to judges in the state in terms of harsh sentences are going to be okay politically, more lenient sentences aren't going to be. And it's to me very much of concern what's happened. And a large number of law professors signed a letter saying, even though we may disagree with this particular sentence, the recall is a real threat to judicial independence.
Can I just return for a minute to the issue of the effect that judicial elections or the threat of a campaign against a judge might have on decision making? And specifically last year, there was a death penalty case before the California Supreme Court where the defendant argued for reversal, saying that judges who are subject to election cannot be impartial because they might be removed from office if they rule in favor of a capital defendant. And the defendant was talking about both the Superior Court and the Supreme Court justices. And do you think, this question to the panel, do you think that judicial elections could ever get to the point where that kind of an argument might succeed under a Caperton analysis?
Well, at the U.S. Supreme Court, there have been challenges that the death penalty is unconstitutional because too many folk of color, percentage-wise, end up being sent to death. The U.S. Supreme Court has not accepted that attack. On the other hand, it seems to me that so many folk who write about those issues keep pointing out the unfairness of the death penalty in that regard. And so it may be that we will reach the point where even the public agrees with it, and if so, I think there's some possibility that the courts would agree with it.
Meanwhile, there's a proposition on the ballot that you can all vote yea or nay on at this election in California.
Well, of course, there's 2 propositions on the ballot.
Yes.
One would eliminate the death penalty. One would eliminate procedural protections to speed up the imposition of the death penalty in California. And the one that, if they both pass, the one that gets the most votes is the one that controls. David, in answer to your specific question, maybe tying it together with Justice Reynoso says, I think there's a real chance that the United States Supreme Court, depending on who fills the current vacancy and likely future vacancies, could declare the death penalty to be unconstitutional as cruel and unusual punishment. Justice Breyer, in a dissent in Glossop versus Gross, June 29, 2015, made the argument that the death penalty is inherently unconstitutional. I believe there's 4 votes for that on the current court. even if they don't go that far, I agree with Justice Reynoso that I could imagine the Supreme Court overturning its decision in McCleskey versus Kemp, which is the case where the Supreme Court rejected the challenge that the racial bias with regard to the death penalty violates equal protection. But do I see a likelihood that the California Supreme Court or the U.S. Supreme Court would say that judicial elections inherently violate due process in death penalty cases? No, I don't think I can imagine the California Supreme Court or the U.S. Supreme Court saying it's judicial elections that violate due process, because I think that they want to believe too much that judges can be and will be impartial.
And the Supreme Court did reject that argument last year unanimously, all 7 justices.
Yeah. We were advised that that our discussion is being recorded, and therefore, if there were any questions, we had to repeat the questions. And I noticed that a lady here had put her hand up. I don't know if it's appropriate.
Yeah, absolutely.
I'm sympathetic to the arguments you're making about the need for judges to not feel that they're going to be influenced by the prospect of having to stand for office or being reelected in the future. But I think that there are some rulings by judges that, for example, the one you discussed about the sexual assault in Northern California, that show that a particular judge's views are so outside the realm of what's accepted in society that I think there should be a need, should be a process to recall that judge or have that judge be receptive to the public's will. And so I can't follow Dean Chemerinsky's argument that we should follow the principle and not allow for an exception of holding a particular justice accountable. I would note his reference to not having any judge being held accountable for a extreme penalty. Not quite correct, I don't believe. I think his reference to the pizza slice case that he was mentioning did lead in California to a backlash against the 3 strikes law, and eventually led to prosecutors utilizing, at least in Southern California, more criteria as to whether to seek the 3 strikes sentence. So I think that for certain judges, when they are so far outside the realm, well, I'm trying to. I think that I can't agree with the panel, and I wonder whether the panel might see that there is some need for accountability for judges who perhaps have racial bias or some bias that's not accepted by society, that's not shown until they are actually faced with certain issues in their tenure.
Yeah, if I might, the question is, isn't there a role for the public when a judge has issued a ruling that is simply doesn't comport at all to the sense of justice of the people of this state? Is that correct? Yes. So that's the question. And I'll have a comment, but I wonder if my colleagues have a comment.
Sure.
I do.
Go ahead. Yeah, okay. Always keep in mind that if a judge's ruling is in error, there are ways of correcting it. That's what appeals are for. Also, if a judge is showing to be biased on the bench, there is a process within this state, every state, for disciplining or even removing the judge. What we're really talking about is, should a judge face recall because the people don't like a particular decision, as was the case of Judge Persky? And here's what you're balancing. You're balancing, on the one hand, the benefit of having that judge removed from office because you don't like a particular ruling, versus, on the other hand, what I'm really concerned about is the effect that has on other judges in terms of how they do their jobs. And I don't want judges to be deciding sentences or cases so as to please the voters and avoid recall. I want them deciding to their very best of ability. So I'm willing to lose something in accountability and not being able to remove the judge who you don't like in a particular case in order to gain overall the judicial independence that comes when judges can decide cases without an eye towards pleasing the voters, without worrying so much about the crocodile in the bathtub.
There's also a politically accountable branch, and that is the legislature. And Governor Brown just signed into law a statute which increases the penalties for sexual misbehavior, which is a way of curing that problem in the long run. And there is the point that Dean Chemerinsky mentioned earlier that is relevant to the question of whether the judge's decision in that case was beyond the limits of what the public should be prepared to tolerate. And that is that what the judge decided, the sentence that he imposed, was within the limits of the recommendations of the probation department in that case.
Yeah. My own reaction was that at first, frankly, from looking at the news accounts, I wondered how could this have happened. But then later, other accounts pointed out that his sentence comported quite closely to the recommendation of the probation department. And my own experience has been that those recommendations normally are pretty fair. So then I wondered whether my first reaction of horror, if you will, was correct. But then, as indicated, it was from my point of view an error in judgment, not an error in law. And then the law has been changed now, so that a judge in the future presumably will follow the new law, and that won't happen again. So as indicated, there are within our system some responses legislatively when a judge has used a judgment that the public generally would disagree with.
Yes.
I remember the election of 1986, and all the attacks on you were absolute lies, and they were all for economic gain. And the trouble is that in these elections, you have these corporations who have a financial interest constantly lying in your ads, and no accountability in political ads regarding, telling the truth. What can we do to fix this situation?
The First Amendment would, the concern is that during the 86 election, those who were attacking the court were very untruthful in many matters that they said. And so how can you respond to that? My first reaction is that we've got the First Amendment to worry about, and so those who were attacking the court had the constitutional right to do that, even to lie, if you will. But I think you've just pointed out the difficulties of having elections and having the resources to educate the public about the role of lawyers and responding to any specific cases. I think it's just a very, frankly, an impossible situation, which is why some of us, including yours truly, think that we ought to come up with a different system.
There's a question handed up about the U.S. Supreme Court becoming political, specifically referencing Justice Ginsburg's recent comments about the presidential campaign and one of the candidates. And Erwin, I know you've written about that issue.
I don't think she should have said it. I understand why she said it. The Code of Judicial Ethics is promulgated by the ABA and exists in all 50 states, says that judges, candidates for judicial office cannot endorse or oppose candidates. That canon, the Code of Judicial Ethics, does not apply to Supreme Court justices. I believe it should apply to Supreme Court justices. I think the same ethical rules that apply to other judges should apply to Supreme Court justices. So what she did not violate any law or any ethical rule, but I think it's wrong for Supreme Court justices to endorse or oppose candidates. One thing, though, that didn't get the media attention that it should have was the timing of her doing this. She made her statements to Adam Liptak from the New York Times on a Friday. It was the day before, on Thursday, that the Trump campaign released the ads criticizing Hillary Clinton for greed with a 6-pointed Star of David superimposed over $100 bills, a 6-pointed Star of David that we now know literally was taken from white supremacist website. She's old enough to have remembered what can happen when extreme nationalist candidates come to power, and I think she was worried if she didn't speak up now, she would later regret not having done it. It doesn't justify it, it doesn't excuse it, but to me that's part of the explanation of what happened.
Yes, over here.
I also, along with the first respondent from the audience, agree with virtually all of what I've heard here and the spirit of it. But I want to propose another situation which might not be so easy to distinguish from the ones that she brought up. That is the United States Supreme Court, by the early 1930s, had come to be seen generally by the public as obstructionist in remedial social legislation in response to the Great Depression, based on legal theories which were beginning to be widely seen as suspect, if not defective. And as a result of the political pressure brought to bear, in particular by one particularly proposed constitutional amendment, by the late 1930s, the court had shifted its position and ceased to obstruct most of the social legislation which was designed to allow the administration of the federal government to address the problems of the Great Depression. Those decisions were not subject to repeal. Those decisions could not be overturned by the legislature. Isn't there some place in a democracy, because the judiciary, precisely because they're insulated from the political process, can become imprisoned subtly in an ivory tower and unaware of changes that are happening in the thrust of the electorate and in the way people are viewing justice. Isn't there a place for politics to illuminate the way that judges are handling their cases and the decisions that they make?
Well,
No,
go ahead.
I guess, at least as I've seen it, the judges are not immune to observing what's happening in society in terms of changing opinions of the public. And in fact, I think that does influence the judges, and I think it should. I think we've seen that, in the acceptance of the courts to same-sex marriage and so on, even before any laws were changed. So my reaction, I was a history major in college, is that in fact, as public opinion changes, that really truly influences how the courts rule on the issues that are coming up before them.
Well, there was the remark of the political humorist Finley Peter Dunne at the time when the Supreme Court flipped on its treatment of New Deal legislation and upheld the first statute, and he said the court had read the election returns. There is the possibility of considering term limits for Supreme Court justices, U.S. Supreme Court justices, which I think is not a bad idea.
I've come to favor that in part for what you say. In part it's because, thankfully, life expectancy is so much longer now than it was in 1787. Clarence Thomas was 43 years old when he was confirmed for the Supreme Court in 1991. If he remains on the Supreme Court until he's 90 years old, the age which Justice Stevens stepped down, he will be a Supreme Court justice for 47 years. So this doesn't sound ideological. Elena Kagan and John Roberts were both 50 when they were confirmed for the court. They stayed to the 90s, 40 years on the court. That's too much power in a single individual for too long a period of time. There's too great a risk that then somebody is truly out of touch with the times. Also, too much depends on the accident of history. Richard Nixon had 4 vacancies in his first 2 years as president. Jimmy Carter had no vacancy to fill in his 4 years as president. I have to admit, I've even come to favor the idea of term limits, and they can be long-term limits for federal district court judges and federal court of appeals judges. There are some judges who are on the bench right now in the federal court who are no longer functioning in the way that they used to or they should be, and we don't have a mechanism to deal with that. And so we can argue whether my idea of 18-year terms for the Supreme Court is right, whether it should be 20 or 25-year terms, long enough that the person isn't going to be deciding cases with an eye towards what comes next in his or her career.
Yes.
So what's being done, if anything, to create a discussion, if not implement some of the changes that have been suggested here? Either term limits and or the middle ground, which I understand is, I'm not sure, Justice Reynoso said from the state of Pennsylvania, Professor Chemerinsky said from the state of New York about reappointment after a certain number of years. So what, if anything, is being done to promulgate these notions and put them up for discussion?
The short answer, I guess, is really nothing. But the longer answer...
Repeat the question first.
Oh, I'm sorry. The question is, what is being done at all in this state with respect to the suggestions that the panelists have had, whether there should be a shorter term, 15 years or so, and then subject to reappointment by the then governor? Should it be just 20 years to allow a change as times have changed and to permit precedents to have sort of an equal chance at appointing new judges? Because right now some precedents appoint none, others appoint many. So there are various suggestions, and the question is what's being done. And I said nothing because, in fact, there is nothing on the table now, but obviously a function like this, a meeting like this, is meant to have us think through what happened in '86 and then go beyond that to have the bar maybe set up a commission to take a look at it and make recommendations and bring this, if the matter is as serious as frankly I believe it to be and my fellow panelists, then the hope is that a meeting like this will proceed to have something more formal, have either the bar or another interested group think that through. There's actually an association of appellate judges, appellate lawyers in California, and perhaps they would be interested. So I think the hope is that it'll be not just thinking about it, but then doing something enough to bring it before the people of this state.
Justice Grodin, we have a question that was passed up that I think you addressed in your book. What would you think of public financing for judicial elections?
I'm in favor of public financing for all elections, but particularly for judicial elections. If we're going to have them, I think it would be a good idea, but that's a tough political sell, I expect.
North Carolina created public funding for judicial elections. However, there's a recent United States Supreme Court case that will make it more difficult to have public funding systems work. It's a case called Arizona Free Enterprise Club versus Bennett. After a scandal involving the Arizona legislature, Arizona voters passed an initiative to create a public funding system for statewide offices in Arizona and members of the Arizona legislature. No candidate was required to take public funding. That likely would be unconstitutional. But it said if one candidate in an election took public funding and the other did not, and the candidate not taking public funding spent more than the public dollars, then the amount of public finance given to the candidate who was taking it would increase. It would increase to a capped amount. And obviously this was to provide an incentive for candidates to take the public dollars without fear that if they do that, they'll easily be outspent. The Supreme Court 5-4 declared that unconstitutional, split on ideological lines. Chief Justice Roberts wrote for the court. Justice Kagan wrote for the dissent. Chief Justice Roberts said, by giving more money to the candidate who takes public funding, if the other side spends a greater amount, you're giving a disincentive to spending money, and that therefore it's unconstitutional. Justice Kagan said, this doesn't prevent anyone's speech. This is just providing more money. If you believe that more money in elections means more speech, this is a good thing. Without that kind of escalator, there's a real disincentive to taking public funding. It makes it much harder for public funding system to work. Of course, this could be one of the cases that's reconsidered by a different court in the years ahead.
Yeah, the Supreme Court has basically said that money is protected by the First Amendment. I never knew that money was protected by the First Amendment. I thought only people were. But basically, that's what the U.S. Supreme Court has said. So I don't think that public funding, and it's indicated, folk don't have to sign up for public funding. But even if you had pure public funding, I doubt that it would be completely responsive to some of the issues that have been discussed today.
Are there any other questions? Well, if not, I think I'd like to ask you to thank our panelists for their time.